Imagine a world in which we can only communicate with subscribers of the same network service provider. The implication of this is that MTN subscribers will be unable to communicate with Glo, Airtel, or Nine Mobile subscribers. However, as a result of interconnection in Nigeria, subscribers of one network service provider are able to communicate with subscribers of another network service provider. Good day, ladies and gentlemen. I am Bridget Fasingha, a 300-level law student of the prestigious Faculty of Law, Niger Delta University, and a participant in the just concluded 5-day webinar organized by HARLEM's Telecommunications Academy in conjunction with HARLEM solicitors. Today, I will be delivering a lecture on the legal framework regulating interconnectivity in Nigeria. The term interconnection was statutorily defined in the Nigerian Communications Act. Thus, pursuant to Section 157 of the NCA of 2003, it defines interconnection as the physical and logical linking of communication systems used or operated by the same or different licensees in order to convey messages to and from the respective systems for the provision of service. Now, we'll be looking at the importance of interconnection from two perspectives. One, from the perspective of the customers. Interconnection eliminates the need for subscribers of one network service provider to subscribe to multiple network service providers. Thus, interconnection is cost-effective and leads to convenience. From the perspective of the operators, interconnection leads to profit, fair competition, improves the quality of service, and prevents discriminatory access. Importantly, we'll be looking at the legal framework regulating interconnection in Nigeria. The Nigerian Communications Act of 2003, hereinafter referred to as the NCA, is the principal legislation regulating the telecommunications sector in Nigeria. Pursuant to Section 70 and 99 of the NCA 2003, it empowers the Nigerian Communication Commission, hereinafter referred to as the NCC, to make regulations for effective interconnectivity in Nigeria. Pursuant to the powers granted to the NCC has promulgated the following guidelines as displayed on the screen. As a general rule in interconnectivity, upon the receipt of a request of interconnection, the requested party is obligated to accept such request for interconnection. This is provided for in Section 96 of the NCA 2003. The interconnection agreement is a legally binding contract between the parties to an interconnect agreement, which stipulates their rights and obligations in the interconnect agreement. The interconnect agreement is to be generated by the requested party and is to be signed by both parties. This brings us to the principles governing interconnection in Nigeria. These principles are the principle of neutrality, non-discrimination, fair competition, universal coverage, access to information, equal terms and conditions, and this is provided for in Section 97 of the NCA 2003 and Regulation 3 sub 3 of the 2007 regulation. It is imperative to note that although there is an obligation on the requested party to accept a notification for interconnection, however, in the following instances, the Commission will limit the obligation on the requested party. These instances are: 1, where such interconnect agreement is prohibited by law. Secondly, where the license granted to the operator does not authorize the interconnect agreement. 3, as a result of technical specification. 4, where such interconnect agreements will endanger human life, safety, or result to harm or injury. The NCA provides the form of an interconnection agreement. Consequently, an interconnect agreement must be in writing. This is provided for in Section 97 sub 2 of the NCA 2003 and Regulation 5 sub 2 of the 2007 regulation. Furthermore, the terms and conditions of an interconnect agreement shall be agreed upon by the parties. However, in the following instances, the Commission, that is the NCC, may intervene and make binding rulings. These instances are: 1, where an interconnect agreement is inconsistent with the provision of the of the NCA or any subsidiary legislation, 2, in the interest of public policy, and 3, as a result of failure of the parties to reach a consensus. Now, when parties to an interconnect agreement have agreed on the terms and conditions, such interconnect agreement must be registered with the Commission, that is the NCC, within 30 days of such execution, or as may be specified in the license. This is provided for in Section 98 of the NCA 2003. Now, when interconnection parties have successfully registered the interconnect agreement, they cannot discontinue or disconnect from such interconnect agreement without a prior approval from the NCC. This is provided in Section 100 of the NCA 2003. One of the things that can result to a dispute between interconnected parties is the interconnection rate. The interconnection rate is the amount of money paid by one telecommunications operator to another for assisting her calls terminate, and the NCC is saddled with the responsibility of fixing this interconnection rates. When a party defaults in remitting interconnection rate to the other party, the party not in default can apply to the NCC for a disconnection of the party in default. The NCC, on considering the application made by the interconnected parties, may grant a partial disconnection. This is provided for in Regulation 9 of the 2012 guidelines. A recent example of partial disconnection can be seen in the publication made by the NCC on the 8th of January 2024 on its official website, whereby the NCC approved for a partial disconnection of Globacom from MTN over its failure to pay interconnection rates. However, this decision was suspended on the 17th of January 2024. Now, this brings us to dispute resolution of interconnection agreements. Section 73 of the NCA 2003 empowers the NCC to resolve interconnect disputes. However, Section 74 of the NCA 2003 provides that the parties are to try to resolve the dispute by way of negotiations first before involving the NCC. It is imperative to state that parties are to apply to the NCC first for a resolution of dispute before going to court. This can be seen in the case of NCC versus MTN, where an action initiated by MTN failed because they failed to apply to the NCC to review interconnection rates before going to court. Furthermore, Section 78 of the NCA 2003 provides that the decision of the NCC is binding on the parties to an interconnect agreement. Furthermore, parties to an interconnect agreement may appeal the decision of the NCC to the Federal High Court. However, pending the decision of the Federal High Court, the decision of the NCC remains binding on the parties. Conclusively, interconnection is pivotal to the functionality of telecommunications in Nigeria. Thank you.